You have all been given an amazing opportunity to take part in the most important free speech event of your lifetimes.
On October 19th, alt-right speaker Richard Spencer came to speak at the University of Florida. When Spencer first announced his intentions to come, students and Gainesville residents were horrified how the university could allow such an event. Students even called for President Fox to resign. Spencer hired a local Gainesville lawyer who defended him despite his beliefs. I asked lawyer Gary Edinger why he chose to defend Spencer, and he said it's because Spencer has rights like any other U.S. citizen. I also spoke with Clay Calvert, First Amendment professor at UF, who explained why UF had to host Spencer. Despite his hateful and racist rhetoric, Spencer never used fighting words, and therefore his speech is protected. It falls under the first rung of the hierarchy of protected speech because of its political and social context. Here is some of his interview with WUFT reporter Eliza Gonzalez.
The First Amendment protects against government censorship, and so therefore the First Amendment is relevant because if the University of Florida were not to allow Richard Spencer to speak on campus, it would raise a First Amendment-based issue. If we were a private university, there would be no First Amendment issue, and a private university could exclude Richard Spencer from campus without raising any constitutional questions. And so Richard Spencer has talked a lot about trying to spark discourse and discussion, and that's actually a useful thing on a college campus, as long as he is not trying to provoke violence and inciting people, his followers, to commit violence. Having discussions about issues involving race, especially in a polarized climate in the United States today, I think are very important.
This example is one of many times when a line had to be drawn to differentiate protected speech from obscene speech. In Chaplinsky v. New Hampshire 1942, the court decided that the First Amendment did not protect fighting words, which, by being said, cause injury or immediate breach of peace. Chaplinsky was a Jehovah's Witness who was preaching on a public sidewalk in Rochester and caused a scene. He was eventually taken to police headquarters and attacked the town marshal verbally. The court decided to uphold his arrest because his words didn't have social value, which somehow Spencer's words are considered political and social and therefore are protected. In Bradenburg v. Ohio 1969, the Supreme Court decided in favor of the First Amendment rights of a Ku Klux Klan leader. The Ohio criminal syndicalism law said it was illegal to advocate crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing political reform, in addition to assembling with groups formed to advocate those beliefs. The court used a two-pronged test to see if it would incite or was likely to incite imminent lawless action. They decided the law was overly broad and couldn't make a distinction. Ultimately, causation can't be proved between the shooting that happened in southwest Gainesville after the Richard Spencer shooting and Spencer's words at the event. Another example of regulation of the First Amendment was Miller v. California 1973. Miller sent out advertisements for the sale of adult material and was convicted of violating a California statute prohibiting the distribution of obscene material. While Spencer's words weren't sexual, this case still relates to First Amendment protected speech by drawing an important line on what is and is not obscene. This case also formed the foundation for the widely used Miller test. In Reno v. ACLU in 1997, litigants challenged constitutionality of provisions in the 1996 Communications Decency Act that was intended to protect minors from unsuitable internet material, like obscene messages or sexual activities in an offensive way. It decided that prohibiting the display of symbols that arouse anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender was unconstitutional. The court decided the act did not clearly define indecent communications. Many of Spencer's supporters openly wore swastikas, which is extremely offensive but protected because of cases like this. A case that was extremely personal for those affected and stirred a lot of emotion was Snyder v. Phelps 2011. A dead Marine's family filed a lawsuit against members of the Westboro Baptist Church who picketed at the funeral because the Marine was a homosexual. Posters read "Fag Troops" and were extremely offensive during, obviously, a time of mourning. The family was awarded several million in damages. The Supreme Court found the words were distasteful but still protected because of where they protested from, which was a public space. This can be related to Spencer's word choice, which is also filled with hate, but is attempting to address social issues. Calvert says that just because we may not like an idea or take offense to it, which is a vague term to begin with, doesn't mean we should ignore the idea, because by doing that we are simply burying the idea temporarily. We're not solving it or engaging in discussion or debate.
So the heckler's veto is clearly relevant to the Richard Spencer event. So the idea of the heckler's veto is that the audience's reaction drowns out the speech of the individual who's trying to speak. So the analogy is, in a comedy club, if the audience is heckling the comedian off stage, then the audience wins, right? The audience gets to silence the speaker. And that is actually anathema or in opposition to everything that the First Amendment stands for. It is the government's responsibility to defend the right of the speaker in the face of a hostile mob-like audience that could silence him.
Something that people who went to the event to hear what Spencer had to say were insulted by.
You know, I came here just drenched in sweat from even getting here, and then I can't even sit and listen to the guy because he's shouted down by a bunch of know-it-all youngsters.
If any of you want to actually have a real conversation about race, let's do it.
For the University of Florida, this means more than $500,000 in security costs. But that essentially can be considered a price that the First Amendment makes the University of Florida pay.
Calvert was right. The University of Florida would have to pay. Because of the sensitive nature of the speech and large protests that the event drew, UF owed local law enforcement agencies more than $3 million in security fees. I interviewed President Fox, who explained the breakdown of the bill.
Mary Grace Scully joins us now with the details.
I spoke with President Fox this morning after he met privately with the chairman of the Alachua County Commission. UF mistakenly paid the county's $302,000 request for reimbursement. President Fox says the county will let UF withdraw that transfer while UF studies the bill.
If you added all those costs together, including what the University of Florida paid, the cost becomes much greater than $600,000. When we were estimating the cost, we weren't including what we thought were all the voluntary contributions of people. It would be about $3 million if you added all that together.
Security that was clearly needed because after the event, a Spencer supporter shot at protesters waiting at a bus stop in southwest Gainesville. The bullet missed the protesters, but still the shooting was exactly what police were trying to avoid. Ultimately, I could not disagree more with any and all of Richard Spencer's beliefs. But as a supporter of the First Amendment, I do understand that he has the right to share these beliefs. I hope that in the future, in a debate, he's going to be proven blatantly wrong and shut down by the lack of having a response, rather not by a heckler's veto.